Okay, we'll get started, guys. If you can't hear me, yell out. I'll go to the microphone, otherwise I'll just wander around. So, this is the topic we've been asked time and time again. In the 70s, a lot of people died and there weren't a lot of disputes about the estates. Reason why? Different sort of economic times in terms of the prosperities come now. We've got compulsory superannuation and people seem to be going with a lot more dollars. You know, what's the average price of a home? It all seems to have increased quite significantly. Also, we have this sort of recognition about the divorce rate and the blended families. You know, what is the normal family? We had one of the advisors, that's a good friend, pop in after 25 years, and I thought, oh, look, I'd have those wills in my safe custody. And I went, oh, no, look, I don't. And then I said, oh, I can't remember meeting his children. And he sat down and he said, look, you know, we've been together, you know, for coming up to 40 years. That was unusual enough in itself, 40 years together. But our daughter, she's with her partner, Karen, and they've got 2 kids, 4 and 6. And I said, oh, right. And who had the babies? Oh, they both had 1 each. Right, okay, good. And who was the dad? Oh, it was the same sperm donor. We went back to the same place, so they're half brothers. Right, oh, good. And your son, yes. And the details, oh, well, he's with a lady whose husband just recently passed away, a suicide. But she's got a couple of kids, but they're happily together. And you're sort of taking down all the notes. You sort of look up and go, how do you like our average family? and you know, it's not a remarkable family. That's just the way it is. There are so many. In fact, if someone came in and said, I've been married to this person for 50 years, we've got 2 children, they have kids, I'd go, boring. You know, it just doesn't seem to happen. That nuclear family seems to be something that, you know, might be in God's textbook or something or other, but it doesn't seem to appear anywhere else. So look, this is a question we get asked on lots of occasions. We want to help the kids out, but how do we protect that? You know, how do we go about this? Because we've heard all sorts of horror stories, you know, down the track about this occurring, and you know, a lady came in and she said, yeah, my husband worked really hard. We've got the 4 kids. They're all in their 30s and 40s. The husband just recently passed away. She said, you know, he never looked after himself. He worked too hard. But he was able to, you know, he bought a place for the girls to ride their pony around on. And that just happened to be on the edge of town. But we quite like going out there and all that sort of thing. This is on the edge of Brisbane. Anyway, look, we sold part of it a while ago. We got 20 million for that. They're going to give us 40 million for the rest. Oh, okay, good. Now, 2 of my kids are going through a divorce. Well, one of them's not really going through a divorce. You know, the husband's living overseas. She's living here. They haven't seen each other for about 4 years. And one of the children went over to visit and found some interesting brochures about escorts. So we think that might be coming to a bit of an end. And my oldest boy, is going through a divorce. And he's had to move out of the family home and he's having a hard time with it. Do mothers and oldest boys have a special bond? Yeah. There seems to be the unbreakable bond, doesn't it? I'm an oldest boy, and if I axe murdered someone to death, my mother would say, no, you mistake. No, it's not video, Trish. No, you really did. Oh, he must have made him very angry to do that. So, this mother, she's going, look, I want to help him out. And what does she want to do? She obviously wants to get him a home, but that's going to be part of the asset pool that Jacinta was talking about before, isn't it? So she wants to get him a home, but she doesn't want that sort of to prejudice what's going on, and she wants, you know, that to come from the trust, because she wants to see him living somewhere so his kids can come and see him and all that type of thing. So that's the question. You know, how can I organise all of this? And if I die tomorrow, because I haven't really looked after myself all that well either, how can I make sure that, you know, this is going to stay in the family and the grandkids and all that sort of thing? Because me and the husband, we sort of built it all up for our kids, but also for our grandchildren and the like, because we didn't want it to be as tough as it was for us. So they're the sort of questions that were being asked, and to be able to answer those sort of questions, I'll try and not do it in a legal sort of a way, but in a way that we'll sort of understand. So Jacinta touched on it before of, here we go. Section 79 of the Family Law Act is where we go. People have been through the experience and know all about it. So it's a pretty simple section that says the court can make orders about property of the parties to the marriage that they think are just and equitable. Now there's a few guiding principles around, but orders that they think are just and equitable about the parties of the property to the marriage. Okay? So property, does everyone know what property is? Everyone's got a fair idea, haven't they? And parties. Who are the parties? Husband and wife. Okay, so just going back to my lady who came in who was worried about her son's divorce, is she a party to that marriage? She's the mother, isn't she? She's not a party to the marriage. But does she get sucked in? Is the trust that her and her husband established, is that a party to the marriage of the son? No, is a sort of the sensible answer, isn't it? That's what we think. But you know, where are we heading in that sort of area? And this first sort of case that sort of took parties beyond just a husband and wife is Ascot Investment and Harper. And what the Chief Justice gives at the time, and he went on to be the Chief Justice of Australia, what he said was, you know, if a company or a trust is just the mere puppet of one of the parties to a marriage, well, I can make orders about that as if it was the party to the marriage. So if you had a husband and wife who had established a trust during their lifetime, put money into it, and they made all the decisions in respect of it, it's going to be found to be a party to the marriage. That sort of makes sense? So they extended the definition of party beyond the husband and wife pretty early in the piece. Because Section 79, it doesn't mention trust, does it? It just said property of the parties to the marriage. You know, that's the only things they can make orders about. But here's the court extending it to trusts or companies or entities which were just the mere puppet or what lawyers eventually turned into alter egos of the parties. So the focus was on the word party. The court didn't really focus on what was property. They said property was fairly well known. If you were a beneficiary of a discretionary trust, all you had was an expectancy or a contingency. It's like gold lotto, isn't it? You pay the entry fee, and if the trustee resolves to give you something, so be it. But if the trustee resolves not to give you anything, there's nothing you can do about it. Is that right? So if we go back to my example before, my lady, she's the trustee of the trust. If the kids want something, they can ask, but what can she say? It's totally at her discretion. That's what a family trust is all about, isn't it? So she could say no. So when does that sort of change? And here we had a sort of a bit of a change, I suppose, in terms of when people talk about bankruptcy, can my creditors access the assets in the trust? The answer continues to be no. Unless those assets were dumped into a trust, just shortly before the bankruptcy or done in contemplation of someone going broke to defeat the creditors, those assets are fairly safe. But in terms of family law, we're saying, hang on, if something's a mere puppet, then that can be accessed by the family court. So there's quite a distinction happening between the bankruptcy courts and the family law court. In terms of going further, in terms of being able to affect third-party rights, so not the husband or the wife, in 2003 the Family Law Act was amended, and what it said was that the family court can make an order, effectively ordering the bank. If Chris and I were together, and Chris and I had a joint debt, but he was going to take a particular property, the family court could order that he takes the debt that's associated with that property. So that's what the section says. There's only one sort of constraint on it. You've got to be reasonably sure that the debt's going to be paid in full. Now, would the bank like that? It's affecting their rights. Now, they had the rights to recover against two people, reduced down to one. What do we know about people in credit, banks, in the last sort of 5 or 6 years? They want every guarantor they can, don't they? And they want to tie them up. Has this section been utilised a lot? No. Because are family court proceedings expensive? Yes. And if you add another party like the National Australia Bank or Commonwealth Bank, they're going to appear, aren't they? Because you're going to notify them, hey, we want to affect your rights. Here's a notice. You can come along to court, otherwise an order is going to be made in your absence. They're going to arrive, and are they going to consent to Chris taking on all that debt? Your Honour, why would you affect our rights? We're not part of this marriage. They borrowed the money from us, we wouldn't be able to recover from both of them. We don't care who has the property at the end of the day, we'll sell it. But if there's a shortfall, we want to recover the debt from both of them. Yes? Okay, so, but here's a sort of classic example of the ability to access third parties. Is it just the bank? This section's not limited to banks, but it seems to refer to them in terms of talking about debts and the like. But this could also refer to a family debt, couldn't it? Where a family member lent money to another family member. And they're saying, okay, you might have lent it to the husband and wife who are now going through a divorce, but because it's the husband's family, we're just going to confine it to the husband has to repay it. Okay, there was a further sort of development of what property means. And quite often we get a lot of queries saying, oh, Richstar, does that mean all my family trusts are no longer going to protect my assets? And again, these cases are now sort of approaching 10 years old. And what do they really mean? These cases haven't been followed, and the reason why they haven't been followed is because they're quite unusual facts. And people sort of forget that when they're branding them around. But in Richstar, does everyone remember West Point? Okay, there's a fine investment scheme, wasn't it? It sort of means Ponzi in that sort of sense, doesn't it? Mr. Kerry operated the scheme, and there was an allegation, can you believe, that shortly before the company went into liquidation, the ministerials were appointed by ASIC, that there were funds moved out of the company into Mr. Kerry's accounts. Can anyone believe that? Millions of dollars, in fact. And he didn't just put them into his personal account, but he put them into some associated family trusts. Now, he was the corporate trustee. He was one of the directors of the corporate trustee. He was the appointer of the trust, and he was a primary beneficiary of the trust. So, under sort of orthodox law, all he had was an expectancy. The trustee hadn't made a decision he was going to get any of this money. ASIC wanted to tie up the money in the trust because they were worried. Are those cases that ASIC brings dealt with quickly? They take a long time, don't they? Now, if all that money that was just sitting there that Mr. Kerry might have or might not have taken out of the company, would it still be there 6 years down the track? They thought that was unlikely. So they wanted to freeze that money so it couldn't go anywhere until the liquidator had been able to ascertain whether it had been taken out of the company or not. And the judge could only freeze it if the Corporations Act said he could. And the definition of property in the Corporations Act said it had to be actual property of the group, it had to be property of Mr. Kerry. It didn't extend to a trust. So this judge, French, who's a federal court judge at the time, he said, hang on, he's a trustee of the trust, he's a primary beneficiary of the trust, he's an appointor, he's got something approaching property interest, I'm going to make the order. I'm going to freeze that money in that trust. Now, he hasn't made a decision that it was property, he's just said it's something approaching property. And it's frozen. The money stayed there ever since. However, French went on, and he's now the Chief Justice of Australia. And in a decision called Spry, the lawyers amongst us here today will know that Spry was the author of our equity textbooks. So he was the guru. But he's just like you and I. He was married for about 20 odd years, 30 years, and his marriage failed. He had 4 kids, and it must have been failing over a period of time because he started amending the family trust deed to exclude himself as a beneficiary, to exclude his wife as a beneficiary, and essentially he vested all the assets of the trust into 4 kids. Why was he doing that? Can anyone see through his very shallow scheme? When it went to the family court, he didn't want there to be any assets in the trust, so that his spouse wouldn't be entitled to anything. So, was he successful? Went all the way up to the High Court, and the High Court said, hang on, there was a trust there, you controlled it for a period of time, you lost control after a while, your wife was a beneficiary of the trust, she had a right to be considered. Add all those things together and you have something approaching the property interest. Okay? Therefore, the court were entitled to make orders about it. again, it's a very unusual decision because Dr. Spry, after the decision, wrote to each of the judges in the High Court and pointed out where they were wrong. In the enforcement proceedings, so he didn't think he had to comply with the orders because they were wrong, he went and cashed all the assets of the trust, cashed them, sold everything, and he had $4.5 million in cash on his kitchen table at home. He then rang his daughter and said, I'm going to burn it. I'm going to make sure she gets nothing. The daughter wisely rang mum, and they raced around to the house. He popped out. They scooped it all up and they took it to the family court registry and deposited it. Unusual facts. Funnily enough, Kennon and Spry, that decision hasn't been followed all that much, but it's certainly a decision that other people would use as authorities because it's a decision they made. So again, these are the cases we've got to rationalise or reason and work out how far do we go to protect our kids. But that's the background. So here we are, 2012. Those cases are almost 10 years old. Lovine and Connor. Now this is a testamentary trust. The facts of it briefly are, we had a dad who passed away and he established 2 testamentary trusts. But he had 3 kids. He had 2 girls, 1 boy. And he set up 1 testamentary trust and he put 2/3 of his assets into that. And he named the beneficiary as his son and any relative of his son as the capital beneficiary. And in the other trust, he put 1/3 of his estate. And with both trusts, he put all 3 kids as the trustee of both trusts. Why do you think he did that? Would you believe that he sort of left out 1 daughter altogether? Remember, he's got 3 kids. He's set up 2 trusts. He's given 1/3 to 1 daughter, and to the son, it appears like he's got 2/3. Do you think that's what he was trying to do? But he's sort of got this funny reference, and any relative. Funnily enough, the daughter was going through a divorce. Anyway, the divorce was settled. There was no order made about the assets in the trust. No one applied for that. After her divorce, he distributed, or the 3 of them as trustees distributed 1/3 or half of that trust to that daughter. Yeah, that's what Dad wanted. With the other trust, the other daughter took out those 1/3 of the assets that she'd received in her testamentary trust. But the son, he kept his 1/3 of his assets in his testamentary trust. Now, who were the trustees? The 3 of them, weren't they? He was going out with his wife one day, they'd been married for a while, and he saw a warehouse. And it must have been in Melbourne or something like that. And they didn't have enough car parking. They collected cars. So they bought a warehouse so they could park their cars. So they wanted to buy a warehouse so they could park their cars. Anyway, they decided, we really like this place, let's buy it. And they decided to buy it together and they signed a contract. Unbeknown to the wife, the husband then changed it so the testamentary trust bought the warehouse. Yeah, so there didn't seem to be any distinguishing. And then they started to park their cars in. These cars, these collector cars. Yeah. They then separated. They said there was a crisis in their marriage. Got the crisis? Everyone knows every day. And then they're going through for a property settlement. What did the wife want to include in the asset pool? Want to include the testamentary trust. Now, whose money had gone into the testamentary trust? A party of the marriage? Clearly not. It was Dad's money, wasn't it? Mum and Dad's money, or Dad's money, because Dad was the last to die. Yep? Everyone agree with that? Who had set out the rules of the testamentary trust that the only person who could benefit were the children and the grandchildren? Was that him or his wife? No, that was his parents, wasn't it? Okay. What about the question of control? Did the sisters exercise any control over that trust? Once the sisters got their money, they essentially just said, brother, you just run your trust how you want. They filed some affidavit material basically saying that. Wasn't all that helpful. So what did the judge say in that case? He controlled the testamentary trust himself. That's what the judge found. And finding the fact, he did things without reference to his sisters. Like he bought a warehouse without any reference to his sisters. The only reference he had to it was to his wife. So, what was the finding? He said that really the Testamentary Trust was the puppet, the alter ego of the husband. And he included in the asset pool that the family court could make orders about. Okay? So here's a case where deliberately set up Testamentary Trust so this wouldn't happen. Quite successful in the divorce of the sister. But by the time the son was getting divorced, what had changed? The trustee hadn't. Instead of having sort of two independent trustees or trustees outside of the marriage, it had gone down to one who was a party to the marriage. So it would have worked if he maintained independent trustees. He would have been good independent trustees if the sisters didn't want to be there anymore. Law firm, accounting firm, financial planner, friend. Well, corporate office. I mean, he's going to look and see who the line is. But, and what role, what sort of evidence would they want to give if they had come onto the family court? Would have wanted to make, the question they'd ask are, Glenda, are you going to act in accordance with the directions of Steve? And what answer did they want to hear? No, I make my own decisions. He's an idiot, he needs my help. Well, you know, there's going to be an independent mind. And unless there's something like that, the family court's going to be able to access the assets of the trust. So, look, there they went back to a decision of Ashton that said, look, if you control the trust, it's going to be included in the asset pool. Because
in the earlier part, where in the first part of the session, we had this afternoon where it spoke about who made the financial contributions. Even though the court would look at the assets of the trust, but the fact that they came from his father would not affect how the court might deal with it.
Well, clearly it affected he was considered. But they said because they had become so intertwined in the family affairs, because there was no reference to the other kids, and because it was just dealt with as an asset of the family, oh, we're going to buy that. And the Testamentary Trust was used. The wife said, I had no idea that the Testamentary Trust bought it. You know, I've been parking my cars there, I didn't ask her for any permission, it's just a family asset. So what I'm sort of saying is the housekeeping wasn't maintained. There was no independence, there was no knowledge, you know, whether there were even financials done for it is another question. So that's where it fell down in the administration. But again, this husband must have been on some sizable income because the secondary issue in this one is he spent $410,000 in legal fees. He spent $682,000 in gifts. So after they'd separated, but before the final orders were made in the court, $1 million has gone. What do you think the wife said? I want that to go back into the asset pool, and I want that to be a distribution to him. I want that to be his share. And what they found was that that $400,000 and that $600,000 were all money, all income that he had made after the separation, but before the property order. And because it was income and not capital, he was entitled to do whatever he wanted. So there was no adjustment made for it, and they weren't disturbed. MacDowell Williams, again, this is one where they were together, I think, 7 odd years, and the parents are 77 and 75. This is the parents of the wife, and the husband said, I want to subpoena Craig's, I want to get the trustee of the parents, I want to get the financials for that trust, and I want the parents' wills. Are the parents getting divorced? They're not. But that's the husband's asked, he's got to grab a subpoena and said, look, you've got to produce those documents. Did the parents want to do that? They didn't, did they? But it's quite private, well, isn't it? They're old enough, but they're in good health, 70 and 75. Their estate was $20 odd million in the trust and personally. The trustee, though, named the wife, their daughter, as a primary beneficiary. She wasn't the only one, there were other primary beneficiaries, mum and dad, the other brothers and So would you have to produce the trust deed? Most likely. Yep. So is that trust of mum and dad, which mum and dad, it's all their cash? That question that Robert was asking before, it's all their cash, it's none of the daughters. Is that something the family court's going to be able to make orders about? Mum and dad control the trust, it's mum and dad's money. What do you think? No? So the judge agreed. He said, this trust is not part of the asset pool, it's controlled by mum and dad, it's not controlled by the daughter. Is it going to be a financial resource that I need to consider in making these final property orders? And really, that's when someone looks over the back fence, don't they? You know, I can't make an order about this particular trust, but I'm going to look over the back fence and I'm going to see what's there. I mightn't be able to grab any of it, but I can see what's there in the future for the daughter, and I can adjust everything accordingly. And they said in the last 10 years, the daughter had only received $23,000 out of the trust out of 2 little small payments. So did they regard, or did the judge regard that $23,000 or that trust as a financial resource? No. So he said, look, you might be entitled to the trust deed, you can have a look, but you can't have a look at the financials because all she's got out of it in the last 10 years is $23,000. Sensible? Sensible result. What about the will? Is the husband entitled to have a look at the will? What do you think the lawyers for mum and dad said? Remember, you've got the husband's lawyers, you've got the wife's lawyers, and you've got mum and dad's lawyers. They said no. That's 2 words, isn't it, Peter? They said no, and the judge agreed. He said, look, they're healthy. They might spend all the money. They might do the ski holiday, mightn't they? They might not include the daughter as a beneficiary. They might give it all to the guide dogs to the blind. Whatever their particular thing. There was no way, it was just purely speculative to say that there might be some entitlement. Everyone agree with that? He said there is an exception. If the parent was about to die, but no, the last parent, the will might become relevant, but only in those circumstances. So that's sort of a sensible result, isn't it? But again, it just goes to show you that mum and dad are not going through the divorce, but here they are receiving subpoenas for details of this information.
Sorry, Steve. Would that condition about if they're about to die also extend to if they're unable to? Remember on previous years you've talked about when someone doesn't have the capacity to.
Yeah, it's a good point. So what he said was the exception was if you're lacking testamentary capacity, i.e. you couldn't change your will, then it might be relevant. But again, if you're not going to die for a while, it seems very speculative. You know, if you had some of advanced dementia, so you didn't have capacity, but otherwise you were physically well, then again it might be irrelevant in terms of who's actually going to inherit. So yeah, look, that subpoena was set aside. So how do we protect the kids from themselves? And what we say here is, okay, well, if we want to help the kids out, this old question always comes down to, Brendan's my son, and I'm going to give him $300,000 to help him out with his mortgage. Should I give it to him and his lovely wife, and come back in 6 months' time and ask them to sign a loan document? When's the best time to ask them to sign a loan document? When you're waiting the cheque, shouldn't you? Because people will sign anything in those circumstances. And would you just get Brendan to sign it? Both will sign it. Oh, fantastic. Thank you, Steve. Give me some money. Are we going to charge interest? No, I mean, if we charge interest, it's a family member, isn't it? And if you're lending money to your brother or sister, you might charge them interest. But most of the time it's going to be interest-free, isn't it? You don't want to complicate your tax situation. All we're trying to do is protect the original amount of capital, aren't we? It's going to get eaten away over time because of the value of money sort of decreasing over time. But we're just trying to protect that capital. So we get a loan document. If we've got a testamentary trust, where did our husband go wrong in that Lovine decision? He was just taking money out of the trust as he required. He wasn't putting any loan documents in place. He wasn't trying to maintain the testamentary trust as something independent for his grandchildren at some point down the track. Was he doing a set of financial statements showing the loan documents and that type of thing? You've got to act on these things, haven't you? You've got to do the right sort of housekeeping if you want to maintain that they're actually something outside of the marriage pool. So again, if you're going to have a testamentary trust and use it, and you want it to be independent of the asset pool of the family, you have to make it, you have to actually act and make it so it is not part of the family pool of assets. So that's why loan documents are preferable. Someone said, should you register the mortgage on the title? Some parents have been surprised they let money to their child to buy a property, the loan documents in place, and they were surprised because they didn't register the mortgage. They said, oh, we'll just keep it here for case we need it one day, that the child went out and borrowed money against the security of the property. So if you want to make sure that doesn't happen, I suppose you register the mortgage. If they come to you and say, look, hey, we want to borrow some extra money, you can agree to defer your mortgage to the bank's mortgage, but at least you'll be in the loop. Always make sure the loan's not a sham. Make sure it's recorded in the financial statements. Make sure you're doing the financial statements for the testamentary trust, because if something's a sham, what's going to happen? Is it going to be disregarded? And everyone knows what a sham is, don't they? Oh yeah, we didn't give that money to them. You know, as the divorces, they start to separate. They say, no, it was a loan. Look, here it is. Here's a loan document, sort of thing. Or, you know, we want them to sign this. It was always a loan. And make sure you do it all the way through. One versus multiple testamentary trusts. So again, coming down to that question, that lady, you know, they're fortunate, you know, had that little farm on the side of town. The trust is probably going to end up, you know, with that $50 million figure in it. She's probably not going to live more than 10 years. So she's controlling that trust. Do you think she should split the trust up into 4 bits and give it to each of her children? 4 kids? Split it equally? That's what she sort of wants the benefit to be. She wants to give that little loan to her son now who's going through the divorce. She wants him to buy that in his own name, his name now. Just go out and buy that. She'll lend him $1 million or whatever it's going to cost. It'll be part of the asset pool, but it'll come with the liability. What do you think her preference is? Split it 4 ways? Given what we've spoken about today? Or should it be all 4 kids in charge of one trust? So I think kids would like separate, wouldn't they? Because then they could do their own thing without talking to their brothers and sisters. But when it comes down to the question of control, then they'd control their own trust and they'd have problems in the family court, wouldn't they? So if you have the one trust, the kids will probably be grumpy that they have to talk to their brothers and sisters about an investment they want to make. But in terms of control, you won't have that control, so for family court purposes, you'll be protected in that regard. So, is there one good answer? It's a compromise, isn't it? Where did Paul Hogan go wrong? He's just lost $33 million, isn't it? So he said, oh look, I'm going into a new marriage, I put my $33 million over in Switzerland with this independent trustee. I know he'll look after that money and always keep it for me. But there's no document saying that. And if I get broke or whatever, you know, there's no document saying that that's my money. What happens when you give up 100% control to somebody else? You can lose 100% of your money, can't you? How much do you lose in a divorce? It's a 50% discount, isn't it? You don't lose 100%. So, and you know, Jacinda was going through those different figures all the time. So, 100% through loss of control is way worse than any family law settlement. So that's, you know, that's the compromise. That's what we're talking about in terms of control. So, children might have to talk to their brothers and sisters about investments and come into some sort of agreement. BFAs, Jacinda touched on very briefly, but what do they give you? What's the whole aim of having a binding financial agreement? They're very romantic, aren't they? 19-year-olds going to sign them? You know, look into each other's eye, we're going to stay together forever. But it's how we think when we're that age, isn't it? And as we get older, we get less cynical. But quite often people have got different asset positions, haven't they? You know, you sort of always meet someone who has less than you. So, the whole idea of when John Howard brought it in 2000 was to give people certainty. Say, hey, while we're mates, why don't we work out? If it doesn't work out, this relationship, how we split up the property. And we'll exclude the jurisdiction of the family court, so no one can go to the family court. Does that sound like a good idea? Has everyone got a 5-star commendation for the family court? You know, they're pretty unpopular places, aren't they? You know, they always sort of say, oh, look, we've mediated it out and both parties are happy. But what they're really trying to say is that both parties are unhappy, aren't they? So if we're able to exclude the family court and we're able to stick to our own agreement that we made at the beginning, that probably sounds like a good idea, doesn't it? So that's what the whole concept of having the binding financial agreements was. But do they need to be updated? They need to be updated regularly, don't they? Because circumstances change. And something that's done now is not going to be binding in 20 years' time because it'll be so irrelevant. Most of us don't even know where we're going to be in 5 years' time. Or I would have thought I'd be here in 5 years' time, but I didn't. You know, you're living somewhere else, children have come along. So they need to be updated at the particular events. The family court are very anti them because it outs their jurisdiction, which they're not very happy about. So when Howard introduced the legislation, very shortly afterwards there was a decision in black and white where the judge said, because you didn't dot the I, literally, it's not, the agreement's not binding, notwithstanding the independent legal advice, all the other requirements were met. The Parliament immediately came in and introduced retrospective legislation to say, if you forget to dot an I and cross a T, don't worry about it, it'll still be binding. There's been a more recent decision in Parker and Parker where the parties sat down, everything had got on by the book, and there was an amendment made at the last minute. Now, the judge found, even though it was only a couple of words, that the lawyer should have given another new advice to the wife, notwithstanding it would be exactly the same as the previous one, should have given another advice to the wife, and he found that the agreement was non-binding. So again, not based upon any substance or unfairness of the agreement, but on a technicality. So again, there seems to be some uncertainty around whether binding financial agreements provide that certainty that we're all hoping for. But again, hopefully that certainty comes back so people can rely upon it. Of course, if you've got an unfair agreement, judges are human. They're not going to, after a 20-year marriage, where one party has $100 million and the other party has nothing. It's very unlikely, if there's been 4 children in that marriage, that they're going to enforce an agreement in those circumstances. What? The circumstances have changed so substantially, it would be unfair to enforce it. That make sense? I just don't think there would be any circumstances where an agreement of that sort of age would be enforced, even though that's what's contemplated, that we always bind them. So you need to update them. And one of the clients, what he's done is, he said, oh, we'll review this every 5 years. His partner said, oh, look, I'm not all that happy about that. How about we make it that the agreement just comes to an end at 5 years? Pressure's on, isn't it? As you get into the 4.5-year mark, if you haven't renegotiated, she might be standing there with the notice. The notice ending the relationship, because that's all you have to give. We were talking about notices before, weren't we? To end the relationship if a new one's not signed within that 5-year period. So there's all sorts of ways it can be done, but this is not sort of, by doing it with a binding financial agreement, you're not trying to hide behind trusts or, oh, it's in my brother's name, my sister's name, my mother's name, it's in my trustee's name in Switzerland. It's a way of doing it sort of upfront so everyone knows. Generation skipping has been a popular question. Hey, I don't really like my kids, but I like my grandchildren. Can I skip them? And it's really just a deferral of the same problem, isn't it? You know, if the children were going to be challenged or lose it, the grandchildren could just as easily be challenged to lose it. So I don't think it's a great succession planning thing. It's just sort of avoiding or deferring the problem. Be careful with the trustees. Everyone's looking for the perfect trustee. If you have a friend who sort of is perfect, the ideal trustee, hopefully they won't change. And it's always a bit of a balance between that control and risk. How far do I go? You know, what sort of a price am I prepared to pay? And how likely is the risk of my child going through a divorce, losing property, do they deserve it? You know, all those things you've got to balance up in your head. Look, plans that have worked. The $90 million man, second spouse, 3 sons. They said it all out what everyone's interests were. He was very happy. He'd been married for 50 odd years. Very happy with his new spouse. They did an agreement. His 3 sons who had worked on the property for a long period of time, in expectation that they were going to inherit it all. They were concerned, weren't they? Very concerned. Were they concerned about Dad's happiness? I'm sure they were, secondary to making sure that their happiness was going to be okay as well. But that was the conflict. They did an agreement. Everyone's interests were noted down. Dad passed away. His second spouse was very happy. The kids were very happy. It had that certainty about it. So it worked well in those sort of circumstances. The 5-year expirations. We've got a young couple who usually their first marriage, every step of their life they've updated the agreement. So when kids came along, they updated it. When they finished having kids, they told us they finished having kids, they put that in the agreement, finished having kids. Some surgery was added to the agreement. Again, got things that are the binding components of it, but then bits and pieces that they want to add in. Who gets a dog, that's all been added into the agreement. Once the covenant worked, a binding financial agreement was entered into a month before Dad died. A 4-year relationship. She received $5 million. She said, I'd never bring a family law claim. That's binding. But of course, after he died, she was entitled to bring a claim because she can't contract out of the succession act. So brought a claim for another $3 million. Where proper advice not given. One party said, hey, why don't you send my mate to your independent legal advice? Not a good idea. And another one where a Filipino will gave advice about an Australian financial agreement. Common sense says it's not that. Okay, questions?